Good afternoon, everyone. My name is Sahar Aziz. I am the Executive Director of the Center for Security, Race, and Rights, and also a Professor of Law and Chancellor Social Justice Scholar at Rutgers Law School, which is where CSRR is proudly housed. I want to thank everyone today for taking time to join us as we address a very important issue by one of the leading experts in the country, and I would argue internationally. Today's lecture is called Settler Colonialism, Race and the Law, Why Structural Racism Persists. It is based on the book that is written by our featured lecturer, and Professor Natsu Saito Taylor. And before I formally introduce her, I just want to encourage all of you to join our listserv and follow us on social media, on Twitter, RUCSRR, Instagram, Rutgers CSRR, and Facebook, RUCSRR. And I do hope that you use our resources page on our website, csrr.rutgers.edu, because we're constantly updating it to try to provide resources for those who are interested in learning more about the topics within our mission, which is the civil and human rights of Muslims, Arabs, and South Asians in the United States, and also the transnational and international events that affect these diasporic communities' civil and human rights. And today we are doing something that is also part of our mission, which is to take a cross-racial and interfaith approach. And so while we focus on, again, Muslim, Arab, South Asian communities, you can't really understand the various forms of subordination or rights infringements that they face without understanding how the same phenomena affect Native Americans, African Americans, Latinx Americans, Asian Americans, and other minority communities. So today, we're very pleased and very honored to be hosting Professor Natsu Taylor Saito, who is a Regents Professor Emerita at Georgia State University School of Law in Atlanta, and a distinguished senior fellow at the Rutgers Center for Security, Race, and Rights. We're very honored to have her among our distinguished senior fellows. And prior to her retirement last June, Professor Saito taught courses on international law and human rights, race and ethnicity, indigenous rights, and professional responsibility at Georgia State's College of Law. She was also a faculty affiliate in the Africana Studies Department. Professor Saito was the founding director of the founding president of Georgia's Asian Pacific American Bar Association and a founding member of the Conference of Asian Pacific American Law Faculty. Professor Saito served for many years on the board of governors of the Society of American Law Teachers, also known as SALT, and was co-director with Kathleen Cleaver of the Human Rights Research Fund. She has published several dozen law review articles, as well as 3 books, From Chinese Exclusion to Guantanamo Bay, Plenary Power and the Prerogative State, which was published in 2006. Her second book, Meeting the Enemy, American Exceptionalism and International Law, published in 2010. And most recently, in the topic of her talk today, Settler Colonialism, Race and the Law, Why Structural Racism Persists, published in 2020. And before I cede the floor to her, I just want to express how grateful I am. As a scholar following in her path, her research has impacted my way of thinking and my analysis tremendously. And so it's truly a personal honor to have Professor Saito here with us today. And for those of you who have not read her book, you must read her book. It's a remarkable piece of scholarship and intellectual thought and intellectual theory. So without further ado, Professor Saito, I will give you the virtual floor. Welcome to the Center for Security, Race, and Rights.
Thank you so much. Thank you for that kind introduction, Sahar, and thank you also to all of you who have taken the time to join us today. I'm really honored to be part of this series on race, security, and empire, and grateful for the work of this center, and also for the work that Professor Aziz and Joe Nagel and everyone else put into making this series possible. I'm in Atlanta, Georgia, where I live and work on lands from which the Muskogee Creek Nation was violently removed, in a city that was made rich and powerful by enslaved as well as convict labor. Like almost any form of redress, land acknowledgements can be counterproductive. but for reasons that I hope will become clear, I believe it's really important to take the notion of being grounded quite literally, to pay attention to the history and spirits of the land that we're on, wherever we are. I've been asked to talk about my book, Settler Colonialism, Race and the Law, Why Structural Racism Persists. I'm not big on theory, but I think that the conceptual lens of settler colonialism can help us see the common structural drivers of the varied forms of racism and xenophobia that we encounter in the United States, understand why prioritizing Indigenous sovereignty is essential to remediating structural racism, distinguish between redress that reinforces the status quo and that which empowers our communities, and envision liberatory alternatives to a system that has proven incapable of ensuring our freedom, equality, or basic human rights. We know that better worlds are possible, and to achieve them, we need to be clear about what's wrong and how it got to be this way. So we begin with where we are. It's scary to acknowledge the harsh realities of life on this planet today. We've triggered catastrophic environmental destruction. Climate change, devastated economies, political turmoil have generated millions of migrants, highlighting the arbitrary nature of state borders. The resurgence of white supremacy, accompanied by racist, xenophobic, and anti-Muslim violence, reminds us that this is anything but a post-racial world. And we see around us every day the effects of apparently intractable racial and gender disparities in wealth, income, healthcare, housing, and education, as well as incarceration rates and police killings. I'm pretty sure you've all seen the statistics. What's harder to grasp is that more than a half century after the civil rights movement, these disparities are not diminishing, and that the gains we've made have been accompanied by consistent resistance and retrenchment. It's increasingly clear that the Constitution's promises of equal protection and due process aren't going to materialize, but we seem to have a hard time envisioning alternate paths. The racial realism that Derek Bell insisted was the key to our survival tells us that if we're going to make meaningful change, we're going to have to let go of the very Western notion of inevitable progress and consider how, as Dorothy Roberts puts it, we rectify a system that so brilliantly serves its intended purpose. A good place to begin, I think, is with our narratives of origin, the stories we tell ourselves about who we are, where we've come from, where we're going, what we fear, what we want, and how we should try to attain it. The dominant narrative, of course, highlights the earliest Anglo-American settlers not as colonizers, but as righteously resisting British colonial rule in their quest for democratic governance and religious freedom. It sanitizes the violence employed against and the exploitation of Indigenous peoples, persons of African descent, and later immigrants. Massive violations of fundamental human rights are relegated to a past for which no one is today responsible, dismissed as the inevitable growing pains of a state that would eventually come to represent the apex of Western civilization. But why did the, quote, founding fathers believe it necessary to kill as many Indigenous people as possible and drive the rest off their land? What motivated the enslavement of millions of Africans as well as American Indians? Why have Latinx and Asian peoples been encouraged to migrate and then summarily excluded or deported? Why the persistent denigration of Islam? And why are the dynamics that fueled these developments still alive and well? What functions do they continue to serve? These are the inquiries that led me to settler colonialism. I'm a third-generation Japanese American whose family was incarcerated during World War II solely because of their racialized identity. As I grew up in the 1960s and 70s, the liberatory potential of a new world order was palpable. Anti-colonial struggles and mass movements against military dictatorships were succeeding in Africa, Asia, and Latin America, inspiring student and youth uprisings throughout Europe and North America. It was a time of tremendous energy and hope. In researching this book, I thought a lot about that era. I remembered that many groups that inspired me saw racial oppression as a function of internal colonialism, and I wondered why, outside of Indigenous communities, I rarely heard anyone talk in those terms anymore. Partly, no doubt, this was due to the social and political repression that decimated the more radical movements of the 60s and 70s. But I think it was also because many of us only understood colonialism in terms of European expansion into Africa and Asia. And while this was a useful analogy, American racial hierarchy only makes sense, I think, if we recognize the United States as a different kind of colonial power, a settler colonial state. Using that lens, much about our histories, both shared and diverse, fell into place for me. So let's turn for just a minute to what we mean by settler colonialism. Generally speaking, colonialism involves the exploitation of land, labor, and natural resources by people or entities, generally states, not indigenous to the territory, and the imposition of economic, political, and social institutions to facilitate that exploitation. Its ideology centers a civilizing mission described by Anthony Angie as the grand project of redeeming the backward, aberrant, violent, oppressed, undeveloped people of the non-European world by incorporating them into the universal civilization of Europe. Colonial relations rely upon what Angie called a dynamic of difference, the, quote, process of creating a gap between two cultures, demarcating one as universal and civilized, and the other as particular and uncivilized, and seeking to bridge the gap by normalizing the aberrant society. The most obvious example of this dynamic is probably the construction of racial classifications intended to facilitate the colonial project. Despite the rhetoric of saving those deemed others, continued colonial rule is justified only to the extent that, quote, civilization is being promoted. And as a result, those who are colonized have to be kept perpetually inferior. Classic or external colonizers typically claimed lands, exploited labor and resources, sent the profits back to their mother country, and ultimately returned home themselves. By contrast, settler colonists came to stay. They rejected control by the metropolitan center and asserted direct rule over colonized lands and peoples. They presume, still, the prerogative to establish their state on someone else's land to create social, political, legal, and economic institutions for their own benefit, and to determine who may not, or must live within their claimed borders. This is why anthropologist Patrick Wolfe famously described settler colonialism as a structure, not an event. Because the colonizers came to stay, land was their first priority and remains a foundational principle. But the territory, of course, was occupied by people who, as Deborah Bird Rose put it, got in the way just by staying home. The early Anglo-American settlers couldn't envision systems of shared land tenure and governance, and were unwilling to adapt to extant indigenous polities. As a result, the forced disappearance of native peoples became essential to their mission. They justified this by racializing American Indians as lawless, warlike, wandering savages, even though the settlers' own documentation demonstrates that they knew better. And this laid the foundation for the invaders' claims that the lands they occupied were both vacant and legitimately obtained by conquest. You've heard, I'm sure, of the hundreds of massacres in which American Indians were indiscriminately killed, entire villages burned, crops destroyed, perhaps about the scalp bounties that were issued in every state and territory, or the sometimes deliberate introduction of infectious diseases. You may not know that at some points, half the children forced into boarding schools never returned home, or that as recently as the 1970s, a massive involuntary sterilization campaign by the Indian Health Service cut the average number of children born to American Indian women in half. That really strikes home to me because that's my generation, my friends, and to think that our children's generation has half as many Native children as it otherwise would is really just kind of chilling to me. Direct elimination has been accompanied by strategies of conceptual disappearance, such as the arbitrary blood quantum requirements used by the federal government since the 1880s to shrink the federally recognized American Indian population, as well as its land base. This reinforces the notion that Indians have disappeared. It's also an attempt to erase indigeneity by collapsing innumerable polities and cultures into a single racial identity, transforming nations into minority groups, peoples that have the right not to be discriminated against, but whose sovereignty is not acknowledged. The experiences of other peoples of color within the American settler state have been quite different. Nonetheless, if we think in terms of the perceived needs of a settler colonial society, it becomes clear that the diverse ways in which we have been and continue to be racialized, exploited, and or forcibly excluded or included have common structural drivers, to borrow Tendai Achume's term. As the settlers consolidated their control over indigenous land, their priority became making it profitable. And to this end, they began enslaving both American Indians and Africans. Examining the African slave trade and the institution of chattel slavery reveals the material and cultural losses systematically inflicted upon peoples subjected to both external and internal colonialism. It also exposes the extent to which enslaved labor provided the agricultural and industrial base for settler consolidation and expansion, an inquiry that's essential to meaningful redress. Enslaved labor was not just convenient, but it was essential to the settler colonial project. And again, racialization provided the justification. Thus, for example, the preamble to South Carolina's 1696 Slave Code explicitly noted that special laws were required because those being enslaved were of such, quote, barbarous, wild, and savage natures as to be wholly unqualified to be governed by the laws, customs, and practices of the colonizers. As Black evolved into a racial classification, it denoted white property and therefore was defined as expansively as possible, in contrast to the restrictive definitions of Indian imposed on those who might have land claims. After the Civil War, Black codes criminalized much of the Afro-descendant population for so-called crimes such as idleness, vagrancy, or disrespect of white people, and fueled a system of convict labor remarkably similar to chattel slavery. By the mid-1900s, we saw a shift from the initial drive to create an ever-expanding enslaved labor force to the perception of Black people as a surplus population to be contained and controlled. Thus, considering the settlers' perceived labor needs lends consistency and coherence to a history that moves from slavery to convict labor to our present carceral state. With respect to other people of color, we see variations on the themes of land, natural resources, and the desire for cheap, preferably disposable labor. Each community has its own narratives, and we don't have time to talk about them, but common themes run through our disparate history. I expect you're familiar with many of the ways that racialization has been used to legitimize the exploitation of land, labor, and natural resources, and to justify ever-expanding structures of social surveillance and control. As they have for more than 500 years, these practices are still framed in terms of promoting and protecting civilization as understood within the confines of a Euro-derivative worldview that orders all forms of life hierarchically and collapses the incredible diversity of human cultures and histories into a tightly constrained, linear path of progress and development. Viewed through this lens, policies and practices that seem aberrational, contradictory, or simply mean-spirited begin to make sense structurally as a function of the settler imperative for land, labor, and social control. But why do we care? Does a different perspective actually change anything? I'd like to share 4 ways I think it can help advance struggles for justice. These fall under the general headings of interest convergence, distinguishing colonization from exploitation, looking to remedies that empower, and dreaming big. First, a settler colonial framing illustrates that even as diverse communities experience racism in very different ways, the motivation to exploit and/or oppress comes from a common source. Discussing race as a function of colonialism meets with considerable resistance in non-Indigenous circles. Indigenous sovereignty is generally cabined in its own discursive sphere, while conversations about racism either ignore Native people altogether or at best include them as simply another minority. But if racialized power and privilege in the United States today are rooted in the historic and ongoing colonization of Native North America, dismantling the colonial relationships that still undergird the state is in the interest not only of Indigenous nations and peoples, but all subordinated peoples of color, and I expect a large majority of those who identify as white. And questioning the legitimacy of states and their claimed borders lets us advocate for migrant rights without reinforcing the myth that this is a nation of immigrants. Derek Bell argued that we only see progress toward racial justice where there's a perceived convergence of interest. When we employ a settler colonial analysis, we see the alignments that allow us to come together to contest ongoing colonization, not just as allies, but because it's our struggle too. My second and related point is that this framing takes us beyond discrimination or exploitation as the root of the problems we face. I addressed this in more detail in the CLE reading entitled Different Paths. There, I noted that the Black Power activist Stokely Carmichael insisted that if we want to dismantle structural racism in this society, we have to begin by acknowledging it as a settler colony. One of his key insights to me was that the exploited and the colonized move in different paths. Because both are oppressed, their material conditions may look similar. Colonized peoples, however, are not only economically subordinated, but, he noted, quote, their culture, their values, their language, their entire way of life are stripped from them, and they're forced to identify with the oppressor. Economic exploitation can be remedied, at least theoretically, by redistributing resources and ensuring access to housing, healthcare, education, and jobs, by consciously eliminating racial and gender disparities or discriminatory practices based on nationality, religion, or immigrant status. I don't think any of this is likely to happen in a settler state. But even if it were possible, two fundamental problems would remain. The first is that a more equitable distribution of stolen goods is not justice. We'd just have more colonizers. And second, it wouldn't rectify what the Kenyan writer Ngugi wa Thiong'o describes as the most problematic aspect of colonial rule, the quote, cultural bomb that annihilates a people's belief in their names, in their languages, in their environment, in their heritage of struggle, in their unity, in their capacities, and ultimately in themselves. And this, I think, this undermining is what we have seen repeatedly with respect to communities of color throughout US history. Because the remediation of exploitation leads only to more equitable distributions of wealth and power, it can be accommodated within the parameters of the Western colonial paradigm. And that's why I think we could emerge from the civil rights movements and the urban rebellions of the mid-20th century with expanded, minimally, but nonetheless expanded access to the privileges claimed by the settler class, but without either redress for historic injustices or fundamental institutional change. Which brings me to my third point. How we frame a problem leads us to very distinct remedial options. According to the dominant narrative, this is a democracy to be emulated by the rest of the world. Our Constitution and laws ensure fundamental rights and freedoms, and racism is being dismantled, if somewhat slowly, by continued enforcement of our rights to equal protection and due process. This narrative, however, cannot account for the patterns of exclusion, elimination, and subordination that persist, notwithstanding our Constitution and laws, and it ignores that large sectors of the population, notably migrants and those most directly colonized, do not have most of the constitutional, or many at any rate, of the constitutional protections, which others of us, at least theoretically, have. Also, this framing relies on an assimilationist, even if multicultural, it's still assimilationist framing that renders indigenous sovereignty invisible and makes racially subordinated people believe that their interests are aligned with those of the state. There's no room in this narrative to address the harm wrought by colonization. But we don't have to limit ourselves to domestic law as currently interpreted and enforced. We don't have time today to get into much about international law, a system that remains tightly controlled by those who wield state power, but nonetheless can help expand our thinking. International law offers much broader protections against discrimination than US law does, based on race, ethnicity, religion, or national origin, and it acknowledges the unique status and rights of indigenous peoples. It recognizes as a foundational principle that all peoples have the right to self-determination, which is, to quote Rob Williams, the idea that human beings, individually and as groups, should be in control of their own destiny, and that systems of government should be devised accordingly and not imposed upon them by alien domination. International law also provides a much broader range of remedies, recognizing that the nature of the wrong dictates the appropriate remedy and that the perpetrator does not get to decide the form or extent of that remedy. If we free our minds to apply these principles, they have tremendous potential to help us assess what would constitute appropriate remedies for the foundational crimes attending the colonization of this continent. In this context, I often think of Robert Cover's reminder that when we believe that only the state creates law, we confuse the status of interpretation with the status of political domination. We ought to stop circumscribing the nomos, he says, and invite new worlds. Which brings me to my final point. Moving beyond the constraints of colonial narratives and relationships can free us to imagine new worlds and to understand ourselves differently. We tend to assess progress toward the equality we've been promised in terms of how class, race, religion, gender, sexual identity, and citizenship or immigration status affect our material well-being. But a settler colonial analysis tells us that these markers of identity have been constructed in order to ensure our subordination. Because our assigned identities are intended to keep us in our place, it's not surprising that they tend to be singular, atomized, and mutually exclusive, not fluid, overlapping, or reciprocal. It's pretty clear that race and gender as we know them are colonial constructs, and this means that relying on them to remediate disparities will ultimately prove futile, I think. Historically, most indigenous nations in North America have been matrilineal, with gendered roles functioning to promote harmony and balance rather than domination and subordination. By contrast, the civilized European state is unremittingly patriarchal. Women are defined as not men, described as less than, less intelligent, less courageous, less competent, less physically capable. Racialization, as we know it, is also a product of colonial rule on this continent and globally. And the issue is not just the particular characteristics that are ascribed to people, but the very notion of race. There's no logic to a system that limits whiteness to those of exclusively European ancestry, defines persons with one drop of African ancestry as Black, and refuses to recognize individuals indigenous to these lands as Indian, simply because their ancestors' names were not inscribed on lists that were created by white government agents. No logic, that is, unless the purpose of racialization is to maintain the dynamic of difference that undergirds relations of power and privilege. The result is what Cheryl Harris calls a racial patriarchy, in which race and gender, as defined by the system, aren't just cultural attributes of European settler society, but essential to the maintenance of the colonial order. Excuse me. In this order, even property is a colonial construct. We tend to assess well-being in terms of disparities in the ownership of or access to property, but that presumes that property as we know it actually exists, and that ownership is defined by exclusive rights rather than collective responsibilities. Many of you are familiar, perhaps all too familiar, with the 1823 case of Johnson versus McIntosh, which relied on the doctrine of discovery to claim that American Indian nations could not, quote, dispose of the soil at their own will to whomsoever they pleased, and therefore they could not have really owned it. The bottom line for Chief Justice John Marshall was that raw power. Conquest, he said, gives a title which the courts of the conqueror cannot deny. But he also noted that his holding might find some excuse, if not justification, in the character and habits of the people whose rights have been wrested from them. What character and habits? As one of his colleagues put it, American Indians were simply wandering hordes held together only by ties of blood and habit, and having neither laws or government beyond what is required in a savage state. This transparently false depiction is what allowed the settlers, presumptively white, male, Christian, and civilized, to claim an exclusive right to other people's land. But my point here is not that the colonizers excluded indigenous peoples from property ownership. It's that the land itself only became property, that which could be held, legitimately defended, and alienated upon its appropriation by white men. And of course, we also have the colonizers' racial construction of human beings, some human beings, as property. So we can't simply assume that property is a normatively neutral reference to material realities. And this means that we need to think beyond the redistribution of property rights. The last colonial construct I'd like to highlight is state sovereignty. Like property, the reality and legitimacy of state power is often taken for granted in our struggles for justice. It has come to seem natural for the planet to be divided up into states, each with virtually exclusive control over its lands and peoples. But there's nothing magical or inevitable or even particularly beneficial about state formations, and no reason to reflexively cede all power to assertions of state authority, particularly when it serves to construct difference and to legitimize the subordination of those deemed other. In the United States, we've seen people excluded from both birthright and naturalized citizenship based on race and national origin, and conversely included without consultation or consent. Consistently, citizenship and immigration status are used to exclude individuals and groups from rights and privileges and to force them to comply with state-imposed behavioral norms. Like racial patriarchy and property, this version of sovereignty has been created by and for colonial interest. If these are the building blocks of colonial rule, it's pretty clear that we won't be able to effect meaningful change in our economic and political institutions or the legal systems that protect them without deconstructing or disempowering these constructs. So to wrap up, Wolf's powerful observation that settler colonial invasion is a structure, not an event, tells us that the decolonizing of settler society will most likely not be an event, but a process or many processes of restructuring. These are processes we can facilitate by refusing to allow our imaginations to be constrained by colonial presumptions, by supporting the right of all peoples to self-determination, and by being willing to imagine societies unconstrained by assertions of state sovereignty. We can defend those attempting to decolonize their lands and communities, even when we might disagree with some of their positions or tactics. The devastation we see around us is not simply the collateral damage of an otherwise beneficial world order, the price worth paying for the marvels of progress. Rather, it's the direct and entirely foreseeable consequence of more than 5 centuries of colonial rule, with its imposition of social orders intent on turning everything encountered into property and assigning worth in terms of the accumulation and control of that property. Is it utopian to contemplate paths that might lead us toward legal, political, or economic formations unconstrained by state power and conceived outside the linear, universalizing hierarchical perspectives currently imposed on us? Probably. But I don't think it's any more utopian than believing we can meaningfully address racism, sexism, homophobia, xenophobia, economic exploitation, or environmental catastrophe within the boundaries of the possible. Thank you.
Thank you so much, Professor Saito. That was brilliant, as expected. What I'd like to do now is encourage everyone in the audience to ask questions via the Q&A function, and I'll moderate. And also, in the meantime, what I will do is ask you a few questions to kind of get the conversation started. So there was a lot there to unpack. And I wanted to ask about this concept of atomized identities that you bring up, because identity politics is wrought with complications. On the one hand, identity politics has united subordinated groups to act collectively in order to combat structural racism or structural bias or structural forms of injustice, because if they don't mobilize together, it absolutely is impossible to do it on your own. And then the question is, where are those borders of identity, and what is it that causes people to make the sacrifices necessary to fight against subordination? So how do you envision this concept of identity within the identity politics literature? But also, I take your point about how atomized identities, or even the construction of these identities, is a product of settler colonialism or other forms of racism or social dominance hierarchies. So I'm interested in kind of your unpacking of these various complicated concepts interacting with each other, or dynamics, I should say.
Yeah, they are really complicated. And obviously I don't have the solution here. But I do think that it's really important to think in sort of structural and functional terms, and to think about what is it, first of all, how to define ourselves and our identities for ourselves. And that doesn't mean that we don't have identities, that we're all like somehow the same, right? We have histories and cultures and communities and practices that unite us and that are historically very important, that give us, for many of us, identities as peoples or nations, right? And those are extremely important. But we have to distinguish those, I think, from the identities that have been imposed upon us. And we recognize that much of the oppression that we encounter is because it's facilitated by those identities. We have to utilize those identities in order to fight back, in order to resist, in order to find common ground, right? If we're all being oppressed because we're classified as X, then being X gives us the unity to fight back against that. But that doesn't mean we define ourselves in those terms. And I think that one of the problems that I see with the way we've been trying to counter, all of these issues for the past many decades is that we've bought into those identities to the point where we end up squabbling over where the lines are. Right. And we look at, you have to be this or that. And, can you be more than one at the same time? No, you have to choose. And, why it's okay for people who are of European and indigenous descent to be identified as American Indian, but there's a lot of moves to exclude people of African descent from being identified as American Indian. I mean, that's just, and that's something that's not just theoretical, right? It affects actual access to housing or, food or school supplies or whatever else of the communities that are being excluded by drawing the lines in these ways. And therefore, I think that, we have to step back and to say, where do our lines of mutual interest lie, that where are the convergences of interest in that sense. But I also think that it is really important to recognize that in many cultures, historically, people were not identified singularly, right? That they could be of this and that nation or people. And you still see in a lot of indigenous communities, people identifying themselves by tracing their mother's lineage and their father's lineage. And those might be quite distinct nations. But that doesn't mean that those people aren't of both of those, or depending on the tradition, right? That maybe primarily one or the other. But, you can be more than one thing at the same time, right? And I think that one of the problems that we're facing right now is that this settler state, insists that our primary loyalty has to be to our identity as Americans. And that's incredibly problematic, right? I mean, just think about, we're supposed to be the nation of freedom of speech and First Amendment rights. Look at what happened to Colin Kaepernick, right? Or Muhammad Ali, or the Black athletes at the 1968 Olympics, right? They were denigrated and hounded and declared to be un-American and unpatriotic and not worthy of any of the recognition of what they had accomplished, because they refused, because they were perceived as putting their identity with Black struggles for human rights ahead of their identity as US citizens. And that was not allowed, right? Stephen Salaita calls this the imperative patriotism of American society, right? And I just think that that's one of the most dangerous things that we're encountering right now. And it's a tool that they're using against us that we have to be very careful about.
Thank you. And I'll just briefly note, for those who are seeking CLE credit, please check the chat you can find all of the information in terms of the code and the website. Okay, so we have a question here that I'll just read to you. It's called, what responsibilities do indigenous sovereigns have to former colonizers when they recover power? I'm thinking here of African countries where European minorities have been relegated to a minoritized status, and the majority has taken action to seize not only power, but resources from the previously empowered minority, including violence. Is this simply a case where settler colonial theory offers no insight, as opposed to the responsibilities of colonists to redress their own privilege? Or is there space from this theoretical lens to address retaliatory actions by those with legitimate grievances?
That is, of course, another very large and complicated question. And I would first like to say that I do think that there are significant distinctions between external or classic colonial relationships and settler colonial relationships. And of course, you know, the Americas are not the only place where we have settler states. So, you know, this settler colonial analysis certainly does apply to some African situations. But those, in terms of this question, I think tend to be ones that were more external colonial situations. But nonetheless, it's an important question. I think that I'm not sure I'm in a position to say what is the responsibility of any formerly colonized sovereign entity. But my opinion is that, you know, all peoples have the right to self-determination, right? And in exercising that right, all peoples also have a responsibility to ensure and protect the fundamental human rights of everybody. So to the extent that we're talking about fundamental human rights, those should be protected by anyone who is exercising any form of power, political, economic, legal power over anybody else. That's a very fundamental bottom line, I believe. And that's part of what determines whether, you know, the exercise of power is legitimate in any given context or not. But that's different. That's a different, you know, that can be distinguished to, there is a line, I'm not sure I can say exactly where the line is, between that and looking at the history of colonialism and the harm that was done by colonialism and what can be done to remedy that harm. And one of the things I didn't have time to talk about, but I think is really important about international law is that it doesn't just look at redress for wrong in terms of compensation, right? It looks at restitution as the primary form for the redress of an international legal wrong. And restitution means, to the extent possible, putting things back in the situation that they would have been absent the violation, absent the harm, right? And then to the extent that restitution is not possible, you look to compensation and measures of satisfaction and rehabilitation and assurances, meaningful assurances that the harm will not be repeated. So, you know, we have to look at that context. We can't just take okay, now the playing field's level and let's see if everybody's being treated equally. We need to look at, you know, what does it take to restore, you know, those states that are being asked about in this question to the status they would have been absent colonial intervention. And that, of course, is not something we can do with any kind of scientific precision, but we can have some pretty good ideas about what it would have looked like. And that's where we start. And then from there, we go to try to, you know, see how we build in these other measures, these other remedies. And it's only by working through the many, many layers of that process that I think we would be able to reach a meaningful answer about whether those white settlers in Zimbabwe have the right to that land or not, or whatever the particular question is.
I'll ask a second question from an audience member, and I'll tack on a little bit. It somewhat touches on what you were talking about. But the attendee says, if this has gotten them thinking about affirmative action in the US and how would applying a settler colonial framework help us think about discrimination, about alternatives, to affirmative action as a remedy for ongoing racial discrimination. If I understand you correctly, says the attendee, it sounds like you would not think that reliance on race in admissions to remediate the longstanding colonial relationship to BIPOC people would be effective. Is there something else that we could be fighting for? And I guess I'll ask that as part of the broader conversation that's slowly gaining traction about reparations. So what are these alternatives, right, to remedy and you touched a little bit on it when you said equitable distribution of resources is not necessarily the ideal model. So what do you think on that?
Okay, so I think that those struggles for equitable redistribution to some, as long as they're undertaken with the fundamental awareness of the nature of the society in which we are and the ongoing occupation that is illegal, even by its own standards, of native lands and resources, right? As long as we're doing it within that framework, that those are important struggles. I'm not saying we don't struggle, right, to get food and housing and access to jobs and employment and all that, right? Because we have to, it's important to survive, and it's important for human dignity. And it's important on all, manner of levels of our being and our society to struggle for equitable treatment. And in that sense, I think the struggles for affirmative action are very important. In the specific context of affirmative action, we have to remember that this was not the solution that people of color came up with. This was the solution that was introduced in response to uprisings of communities of color. We're talking about the mid to late 1960s, when hundreds of cities were burning every summer, right? Like we saw, in 2020, right? But on a much more massive scale. And the National Guard was being called in, and there were tanks. And the powers that be saw their society, their investments, their whatever, being dramatically threatened. And, you just go and read the Kerner Commission report, right? That was the commission that was put together at President Johnson's request of leading corporate and political figures, mostly powerful white men, to come to try to understand what was happening and why it was happening and what was the solution. And the Kerner Commission's report is remarkably honest, right? They said it is white society that is creating these problems, and it is the inequities in the so-called ghettos that, are creating this response, including police violence, but not nearly just limited to that. And if we don't do something about it, all our stuff's going to be burnt up, right? So we need to do something about it. And we start getting welfare, a little bit of welfare reform, and a little bit of, more access to this, that, and the other. And we start getting affirmative action, right? So instead of actually dismantling racism in this society, it was like, ooh, we're going to keep the fundamental structures as they are, and we're going to let a few more of y'all in. Now, that's important. We need to be in, right? But it's not going to fix the problem. And so, yes, I think that any measures of affirmative action that we have right now should be protected and defended and maintained. But they're not going to solve the underlying problems. And so we have to take defensive actions on every front, especially right now, right? But we have to think about, as we do that, what are the most effective and empowering ways to do it and struggles to engage in. One of the things I quote, I think in that article, is what Stokely Carmichael said about voting rights, right? He was arrested dozens of times in the South, fighting for voting rights, even though he didn't think voting was going to make any difference. And somebody said, like, why are you doing this, right? And he said, it is because, I might not get this exactly right, but he said it is because the attempt to prevent Black people in the South from voting is, as he put it, the white man telling the Black man, you are not allowed to do this, right? And the Black man saying, I am saying no to your constraints. I am standing up to your attempt to confine me and to keep me in this place. And what Stokely was saying was that, you know, anytime people stand up like that, we have to come to their defense and we have to help defend and empower them. And I think the same thing is true with any struggle, right? We could say any given struggle, affirmative action, or, you know, trying to bring about a police commission to look into, you know, whatever the latest episodes of police murders are, whatever, right, is futile. And historically, these things have tended to be futile in the long run in many respects. But the question is the struggle itself and the way in which the struggle being waged, is it empowering a community? Is it inspiring people to say, yes, right, we have the ability and the right to envision a society that we want to live in and to create that society and to take the power back into our own hands. And I just feel like that's how we have to look at these things. Now, in terms of the bigger question of reparations, again, I think we have to go back to the questions, the big questions, right? What are the wrongs at issue, right? What are we trying to redress, right? And what would effectively get us there? And in order to do that meaningfully, I don't think we can do that in any way that will bring about fundamental structural change unless we look at the wrong that's entailed in the occupation of this continent, the wrong that's entailed in the enslavement of millions of people of African descent, the wrong that's entailed in the exploitation of other migrants of color, et cetera, right? And then we start from there. Now, does this mean, okay, so we figure out that X trillion dollars is now owed to the descendants of enslaved Afro-descendant peoples? Does this mean, you know, we're going to get X trillion dollars? Of course not, right? But it gives us a framework to say, okay, you know, settler society, you have benefited by X trillion dollars from this labor. You know, let's start talking about how we redress that from that point, not from the pretense that this is a level playing field and I'm not scoring as well on standardized tests as you are.
Okay, I want to push you a little on details, or maybe if you have a case study, or whether it's with Native American communities or, you know, other minority communities. But I think it would be helpful. We have a lot of students on this webinar, and what is an example or a case study where the law, if there's any hope in the law, and I you know, there are certainly scholars who think that everything should start from scratch because the law is absolutely a product of, you know, whatever country's hierarchies. And in this case, you know, you're arguing settler colonialism. But is there any specific examples that you found have worked? It could even be outside the US, but just to add a little bit of detail so that people in the audience can envision how these concepts could produce some change. Positive reforms
in the law, like a legal.
Yeah.
Okay. Yeah, I'm trying to think of what might be a good one, but
and perhaps think of it as, I mean, you and I are both critical race theorists. How do we teach this, you know, in a law school when we know that there are these very large problems, structural problems, but at the same time, we have a legal system that either we could say it's completely illegitimate and needs to be uprooted and started from scratch, or it needs to change in ABC ways. I mean, this is a challenge we all face as professors.
Yeah, no, and I will try to get to your question about a specific example, but let me just say that I am not somebody who believes that we should just disregard the law or say that, you know, it's meaningless, right? I think actually the law can be very helpful to us. I mean, think about treaty rights and treaty enforcement, right? There are so many more than 400 ratified and more than another 400 unratified treaties with indigenous nations that the United States has. These are their treaties, their laws, right? Rewritten by them, generally speaking, and ratified by their Senate, et cetera. You know, enforcing those would make a huge difference, right? So, you know, the law as we have it is extremely problematic, but if it were actually being enforced, we'd be a whole lot better off, right? The same is true with, police murdering young Black men. That is clearly illegal, right? We need to be getting that law enforced. And it's not like there's not some recognition, even in that quote from Johnson versus McIntosh, right? Justice Marshall said, those indigenous peoples whose rights have been wrested from them. He said, we have taken away their rights, right? And what are we supposed to do? We're the courts of the conqueror, right? So in the legal system as we know it, there are all sorts of, contradictions that we can highlight and press on to try to help remediate things. I don't think that ultimately that is going to bring about the dismantling of some of the most fundamental structures that reproduce the racialized and gendered and otherwise problematic harms that we've been talking about, right? We also have to do the restructuring piece of this. But there's all kinds of things we can do with respect to pushing the law to live up to its own promises, and also to using the law to defend and protect people. Because first of all, we have to ensure that our communities survive, right? We have to get people out of jail. We have to, do all of those things, even if it's not bringing about fundamental social change. We have to survive. So, that's part of it. And I think that there's also, in terms of using the law outside, there's some really great examples that I think are important for students in international human rights law. Okay. Now there's this real tendency to say, oh, international law is not real, blah, blah. And first of all, that's just not true. And if you look at the United States history, the United States has acknowledged since its very beginning that international law is very important. And the United States has tried to justify itself and to put itself out as a leader in terms of the formation of and compliance with international law. But it is true that it's very hard to get American courts to directly enforce international human rights law, possibly because most of those judges never had any courses in international law and they don't know anything about it. So my first tip for law students out there who might be going into international law is, whenever you're bringing up an international law point, you have to very politely and respectfully explain from the most basic principles, right? And the most basic US Supreme Court cases that say international law is part of the law of this land, right? What international law is, so that the judge has some clue about what you're talking about. But generally speaking, the judges aren't going to rule on that basis. But there have been many cases in which, by introducing international law and human rights law in particular, courts have changed their interpretation of constitutional rights in a direction that brings the enforcement of the Constitution closer into compliance with international law. We have seen that in some recent Supreme Court cases. I'm old, right? Recent is like any time in the last 20 years, but court cases with respect to the juvenile death penalty, right? Or the execution of people who are disabled. And even though the court has not said we're doing this because everybody else in the world has outlawed the juvenile death penalty, it has clearly had an impact on them. It had an impact on the interpretation way back in the I might have the date wrong, but after World War II, when there were challenges brought to California's and other alien land laws, which said people who were ineligible to US citizenship couldn't own land. Well, ineligible to citizenship was based on the prohibition initially of anybody other than free white persons becoming naturalized citizens. And by the 1940s, that had been chipped away, but there were still people who were, Asians particularly, who were being excluded from land ownership, who were excluded from naturalized citizenship and therefore from land ownership, right? And there was an important case where the UN Charter and its prohibition on racial discrimination was brought up. And the courts, they weren't going to say, you know, oh, we're changing our interpretation and ruling these state laws unconstitutional because of the UN Charter. But the same court that just a few years earlier had said, oh, there's no problem with these alien land laws, they're just fine, said that they conflicted with the 14th Amendment provision for equal protection, right? So we see actual changes come about, even though they might not be acknowledged as stuff. So there's all sorts of ways to use the laws, domestic law and international law, I think, to actually bring about change that is significant.
I'm glad to hear of your optimism. I think a lot of us still struggle as to, well, the law is a sword and a shield, right? So it can be used for good or bad.
Can I just say one other thing about that?
Go ahead.
Especially with respect to the use of international human rights law. And I'm seeing this a lot now as international law with respect to indigenous rights has expanded dramatically. It is tremendously important for subordinated and oppressed and exploited communities to see that there is law out there that supports them in their struggles, even if we can't get courts to enforce it, right? People know that they are being wronged, right? That they are being exploited, that they're being, you know, whatever horrible thing is happening to them is not okay, is not right. But often in US courts, right? And as lawyers, right, we're always telling our clients, well, I know that that's not right, but I don't know if we can get you a legal remedy or not, because there's these evidentiary standards and there's statute of limitations and there's blah, 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 right? And so the message from the legal system is often, you know, you don't have a legal remedy here, which makes people feel like it's okay for them to be treated wrongly. And for us to be able to bring other law and particularly international human rights law to them and say, look, the US courts might not enforce this, but the whole rest of the world is saying you are correct. You have a right to healthcare under these circumstances. You have a right to maintain your culture or to educate your children in your traditions or whatever it is, right? That's really important and empowering and enhancing of human dignity, I think.
Thank you. So there's one other question that's kind of the flip side of it. And I'm going to give a shout out to a colleague, Professor Neil Gatanda, another person who, those in the audience, if you have not read Professor Gatanda's work, I would rush and read it this week. He's amazing. And so thank you, Professor Gatanda, for attending. And his question is about the current case on the Indian adoption law. And as he frames it, it's another aspect of current Supreme Court's majority, part of the effort to abolish even the limited sovereignty that has been recognized by imposing racial remedies in a punitive fashion. So structurally, like abortion, indigenous sovereignty can aid delegitimization of Supreme Court majority. So just in general, do you have any insights or comments that you have about this current case where apparently there is a challenge to overturn or to repeal the Indian adoption, I'm going to get it wrong, the American Indian Child Welfare Act, right? And perversely arguing that it's racist because it effectively requires or preferences families that have Native American heritage in terms of being able to adopt children who are also Native American. And so it appears that it's white, if I'm not mistaken, it's white parents who are seeking to repeal this law. So there's kind of this is the flip side of the international law optimistic angle, but I think it's very relevant to our discussion here. So whatever insights you have would be really valuable.
Well, thank you. And my shout out also to Neil Gatanda. And Neil, you can probably answer this question much better than I can. And I have to admit that I have not been following it as closely as I intended to be this past week. So I can't speak really specifically to it, but I do think that it is a reflection of this very problematic trend that we have seen that really goes back to the point I was trying to make about the collapsing of indigeneity into a racial classification and why that's so problematic, right? Because peoples and nations have rights, have sovereignty, right? Not state sovereignty, but sovereignty, right? And there has been this attempt to say that everyone, that rather than having rights as peoples, they have only the rights of a racial minority, which means the right not to be discriminated against, which is very, very different, right? That's a completely assimilationist perspective. And even if you say that, oh, this is, you know, not just the melting pot, but a country of many, many diverse cultures, et cetera, if the objective here is to incorporate and assimilate everyone, you know, with their diversity into this society, that reinforces the legitimacy of the settler state and is very problematic. And we saw this, right, in the Hawaii case, right, where previously, right, a case called Morton versus Mankari had said that the preference given within the Bureau of Indian Affairs, an employment preference, right, the Bureau of Indian Affairs, after hiring only white people for a really long time in any kind of positions of power, said, oh, you know, gee, maybe we should give some preference to hiring some Indians in these positions. And lawsuit was brought against that. And the court at that time said, right, it's okay because this is a political classification, not a racial classification. And when there was a challenge brought in Hawaii to the Hawaiian, I might not get this exactly right, but the Office of Hawaiian Affairs election procedures for the entity that oversaw the management of Native Hawaiian trust lands, in other words, lands that were Native Hawaiian lands, right? That it shouldn't just be Native Hawaiians who are allowed to vote for the people who are going to be managing these lands, but white people should be able to as well. And most of us thought this is a slam dunk Morton versus Mankari political versus racial distinction. But no, the court said in Rice versus Cayetano that it was racially discriminatory to exclude the white voters, right? And so now there is great fear that what the court is doing is bringing that way of thinking to the Indian Child Welfare Act provisions. Now, you know, again, this is completely taking an ahistorical lens, right? It is completely ignoring why do we have an Indian Child Welfare Act, right? It's because 5 generations of Indian children were stolen forcibly at gunpoint from their families and forced into boarding schools, where, as I said earlier, in some generations, half of them didn't survive, right? And then there was this tremendous effort to take American Indian children away from their families on the grounds that they were unfit. The families were unfit, and to out-adopt them with white families, right? Tremendous. It was a concerted effort to assimilate American Indian children by taking them away from their cultures and their families and their communities, and to put them with white families so that they wouldn't be Indian any longer, right? And this was being done extremely arbitrarily and on a really widespread basis. And it was countering this, right? And we had those dynamics on top of the sterilization issues, right? So this was really endangering the ability of indigenous peoples and communities to survive. And that's why we have the Indian Child Welfare Act, right? To say, right, first we look to the children's Indian communities to see if there's somebody that would be a good placement for them. It didn't say no white people can ever adopt Indian kids. It said first we look to see, is there a way to maintain these children's cultural, you know, situatedness because of this history? And if not, then, right? But that's all just, you know, in danger, I'm afraid, of being lost.
It's very regressive. We are definitely seeing the cycle that we've seen historically of retrenchment. Right? After the 2020, after the election of the first African-American president, and then white nativism has a recruitment boom. You get the protests for Black Lives Matter, and now you have a very aggressive backlash. And I think just that phenomena of this constant backlash, rather than embracing the fact that the country is, at least I think a lot of young people want change in this country that at least chips away at these hierarchies that are privileging, certain identities, white, male, heterosexual, Christian. Yes, this is a very exciting time to be living alive in America. I'm going to end with one more question from one of our audience members. How can universities, settler colonial institutions that are themselves settler colonial institutions, engage in self-accountability and reparation regarding their own contributions to maintaining the status quo in terms of ongoing white-centric production of knowledge, different hierarchies, and power imbalances in society? Big question, I know.
In our remaining 1 minute, I will give you the magic answer. But that's a really good question. And it's one that we have struggled with. And honestly, I don't think the answers are all that mysterious. I think it's a question of willpower, right? I think we look at what we're doing. We look at the history of each, of universities in this country generally, but also each individual university. What has been the purpose of those? What has been the trajectory of them? Who have they educated and to what end, right? And, one of the big, the regressions that you were just now referencing has been in education, right? In education at all levels, including in higher education. And we see this really clear history of, in the 60s and 70s, again, the mass social mobilizations and the burning down of stuff, right, brought about this recognition that we had to open up education systems and universities. And there was this little crack in the door where we started to get ethnic studies programs, African American studies, blah, blah, blah. And it made a difference, right? And those are now being attacked, right, as critical race theory, blah, blah. And they're being shut down. So first of all, we have to defend the actual ability to teach real history, but we have to recognize how limited that's been. It's been cabined very much. It has not really permeated other disciplines. So really, we should be looking at the way in which all of these disciplines, the canon, the accepted premises of, psychology and philosophy and history and English and all of these disciplines, right? And the sciences as well, right? How narrowly they are framed within an incredibly Eurocentric worldview and understanding. So we have the actual people that are involved in these institutions and the need to bring real diversity there. We have the curriculum and what is being taught. We have the way in which knowledge is being constructed and reproduced. We have the ways in which the institutions are being assessed, right? And we have the questions of free speech within the universities. There's all those issues, in addition to the very concrete things of whose land are we on and how did we get here, right? And, whose labor built this building and all of those questions. But I think, to me, those are all pretty straightforward things that we've known and we've been saying, those of us in the academy who care about these things, for decades. And in my experience, our colleagues say, yes, 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 of course, that's very important. Let's have a committee to look into something and come up with some suggestions, right? And then, 2 of the 10 committee suggestions get implemented maybe over the next 3 years. And then we wait until something burns down again. So I think it's really a question of how do we motivate our institutions to be willing to do this? And that's where I don't know if we'll be able to do it or not.
Well, there are a lot of open questions about the changes in the demographics of the country. And I think your points about identity formation and more young people saying, I'm mixed, and whatever that means, because we all do have multiple, we're all mixed if we're going to be using these social constructions of race. So there's a lot of exciting, hopefully positive developments coming up. But on that note, I want to thank you so much for taking the time and generously providing your expertise on these important issues. Anyone who has not read Professor Saito's book should read it. Make sure your libraries have it. Settler Colonialism, Race and the Law, Why Structural Racism Persists. It's beautifully written and masterfully researched. And so it's truly an honor. After I read your book, I said, I've got to have her come and speak at the center because it's so timely. And I want to encourage the audience to please follow us on social media, the Center for Security, Race and Rights, RUCSRR, or Rutgers CSRR. And if you are in a position to donate, please donate to the center. It is your donations that allow us to continue this important work. We are donor dependent, very intentionally so. And so go to csrr.rutgers.edu, press the donate button and give whatever you can. And I will put in a plug for our next talk, which is called European Islamophobia by Dr. Farid Hafiz. And that will be on December 7th. If you go to our website, you will find the registration link. And we also, as part of our series of race, security, and empire, we also have 3 exciting lectures coming up in the spring. Professor Aziz Rana, Professor Heba Gawayed, and Professor George Bisharat, all on various aspects of, one on U.S. foreign policy, one on international immigration and refugee, and one on Palestinian human and civil rights. So we've got a lot of exciting lectures. But with that, I want to thank you again, Professor Saito. I want to thank everybody who attended, and I wish you all a wonderful day.
Thank you so much.